Director of Traffic revoked the driver's license of Mark J. Hanna for a period of 1 year for failing to submit to a chemical test following an arrest for driving while intoxicated. Hanna filed a petition for review. After a hearing, the commissioner determined that the arresting officer lacked probable cause to believe that Hanna was driving while intoxicated. The judge adopted the commissioner's conclusion and entered judgment restoring Hanna's license. The director appealed. The director called one witness, the arresting officer of the Chesterfield Police Department. The officer testified that on January 1st, 1999, he saw a pickup truck on the shoulder of Highway 40 with the engine running. He pulled behind the truck and saw the occupant, Hanna, sleeping in the passenger side of the cab. The officer approached the passenger side and woke Hanna. According to the officer, Hanna said that he was looking for the police station and gave the officer a passport for identification. The officer noted a strong odor of an intoxicating beverage and testified that Hanna's eyes were watery, glassy, and bloodshot. He testified that when he got out of the truck, he used the passenger side door to keep his balance. The officer noted that the front tire of the truck was flat, and there was some damage to the wheel rim. The officer testified that Hanna said he had fallen asleep while driving and struck a concrete barrier. The officer arrested Hanna for driving while intoxicated. Because of adverse weather conditions, the officer transported Hanna to the police station and performed field sobriety tests. He advised Hanna of the implied consent law and asked him to consent to a chemical test for blood alcohol. The statutory term chemical test can refer to the breathalyzer or a test of a sample of the person's blood. He informed Hanna that if he refused to take the test, that his license would be revoked for 1 year. Hanna refused to take the test. During cross-examination, the officer acknowledged that he had not seen Hanna in the driver's seat. The officer testified that from the odor of alcohol from Hanna, he could not determine the quantity or quality of that alcohol, and he could not determine whether Hanna was intoxicated. He also said that Hanna's bloodshot eyes could not lead him to the conclusion that Hanna was intoxicated. The officer also acknowledged that Hanna might have needed to balance himself with the truck door because he had just awakened and needed a period of time to balance himself. Hanna called two witnesses. The first testified that he had been driving, not Hanna. He testified that he was driving when he hit a pothole which flattened a tire. He walked down the highway and someone picked him up and dropped him off at a gas station where he used a telephone to call his brother to pick him up. The second witness for Hanna testified that he met his brother at the gas station and they drove to where he had left Hanna, but Hanna was nowhere to be found, presumably because of the arrest. The trial court concluded that the officer did not have probable cause to arrest Hanna for driving while intoxicated. The record does not disclose any request by the parties for findings of fact and conclusions of law. The object and purpose of implied consent law is to rid the highways of drunk drivers. Shine versus Director of Revenue, 807 Southwestern Reports, 2nd, 163, Missouri Appellate Division, 1991. The implied consent law was adopted to establish a fixed standard for procuring admissible evidence of blood alcohol for use against persons operating automobiles while intoxicated. State versus Paul, 437 Southwestern 2nd, 98, 103 Missouri Appellate Court, 1969. The statutes central feature is that any person who drives on the public highways is deemed to have consented to a chemical test to determine the alcohol or drug content of the person's blood.